Welcome to my channel Journey of Constitution of India. This is part 1 of Article 16 Right to Equal Opportunity series. The journey of Article 14 to Article 15 and then to Article 16 is a journey from general concept to spatial utilization. It means that first a genius person put an idea, brilliant idea, and that idea was put to hard scrutiny by advisory committee of Constituent Assembly, then a detailed discussion by the Constituent Assembly, and it was drafted by using meticulous words and then put in the Constitution. But the third stage of the journey was the implementation of those provisions for the welfare of people, and then getting the response from there and reincorporating the responses and amending the constitution to make it more responsive to the need of the people. Our constitution is a living document because it gets and it changes with the changes in the society and the values of the society from time to time. Article 16 is for equal opportunity in public employment or employment under state. The issue involved here reminds me of the concept given by Granville Austin, where he said that our constitution being a seamless web of three strands, and one of the strands is fundamental right and the other strand is the social goal for removing equality, and which was before the constitution framers. Granville Austin is a great commentator of the Indian Constitution, and I, being a student of law, have benefited from his work, and his work is original and worth reading. So please, if you have time, you go through his books. Very often, the Constituent Assembly of India is compared with Philadelphia Convention 1787 and the States General of France 1789. But there is a marked difference which I feel from those two bodies, American and French bodies, and our Indian Constitution, the Constituent Assembly, was that in case of Indian Constituent Assembly, there was a strong political participation and struggle over a long period of time, and the political parties were strong in this in the Indian perspective. And the Constituent Assembly was constituted at the stage when this political system were very strong in the country. The presence of a strong political party, and the strong political participation of Indians had given a strict distinction of the Constituent Assembly from those two bodies which I have mentioned earlier. Another distinction of Indian Constituent Assembly was that it was entrusted with a special burden to work for the social equality. The caste system in India is unique, and it is not found as it is found in India. It is not found anywhere else, and it is very deep rooted in our Indian society. The Constituent Assembly worked for about 3 years and framed a longest constitution of the world. The ideals of freedom movement were translated into the constitutional provisions. The most onerous duty of to protect the socially backward communities and to bring them in the mainstream and ensure their political participation and representation in government. So this was the onerous duty with the Constituent Assembly. Everybody was agreeing for establishing an egalitarian societies and vociferously argued for it at that time. The concept was expressed by Pandit Nehru in the words of Pandit Nehru at the time of setting the objectives of the constitution, where the concept of egalitarian society was explained. The issue of reservation was pleaded, explained, accommodated, and accepted by the national spirit as a national spirit of the constitution. Even today, it is a part of the mainstream discussion. One after other caste is trying to enter into the fold of reservation provided by the constitution, and this thing became more peculiar and more stark after the implementation of the Mandal Commission, where a 27% reservation was given to the other backward classes, and a large number of backward classes were taken into its fold. So this Article 16 in detail deals with all these aspects. Let me quote a sentence from uh, a judgment of Supreme Court in Jaintia Hill District Council case. It says, quote, Article 14 lays down the rule of equality in the widest term, while Article 15 prohibits discrimination on the ground specified therein, but covering all range of state activities. Article 16 confined itself to the same rules but in narrower sense and to employment under state only. I would like to refer the commitment of Constitution in the preamble. Solemn resolution was to secure all its citizens equality of status and opportunity. Article 14, 15, 16 have different modus operandi to secure the equality of status and opportunity as enshrined in the preamble of our Constitution. What Article 16 grants is or guarantees is equality of opportunity in matters of appointment in state services. However, it does not prevent the state from making any necessary qualification or rules or pattern of examinations and whatsoever. But the basic thing is it should be open to all citizens without any discrimination. Let us discuss the various clauses of Article 16, which is a complete code in itself. There are 6 clauses of the Article 16. The first 2 clauses are general clause, and the rest 4 clauses are enabling provisions, because it enables the state or parliament to frame laws to secure the end of equality, because the unequal in the societies cannot be treated equally, so they need compensatory discrimination, and these 4 clauses are in the form of providing compensatory discrimination to make a level playing field. In this part, we will discuss clause 1 and clause 2. Clause 1 of Article 16 in very simple language says, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under state. There are 3 phrases in this clause which are very important. First, equality of opportunity means public employment is open for all citizens. There should not be any discrimination on any ground, so it should be open to all citizens. The second phrase is employment or appointment, means these 2 words cover even pre-employment phase and post-employment phase and all the services conditions. Third, any other state, any office under state, means the definition of state is given in Article 12, which is very comprehensive, all inclusive. So here the word state should also be considered within the ambit of the definition provided in Article 12. Purposely, the clause 1 is made very comprehensive, wide, and applicable to all employment under state and to all citizens, covering the period of pre-employment or post-employment, because this is a general clause. The clause accordingly does not prevent the state from laying down any requisite qualifications for recruitment or any categories of services, or laying down the conditions of the services. But one thing that is to be kept in mind, that it can put any condition for the purpose of maintaining the efficiency and cleanness, transparency in the administrative work. The expression matters relating to employment and appointment must include all matters, and that should be free and reasonable, non-arbitrary, as discussed we have discussed in Article 14. Even the principle of equal pay for equal work is flowing from the idea or the concept and the provision of section article 16 clause 1. Now the clause 2, that is very important. That is very important for one reason, that it travels beyond the area of offices or employment with the state. So it goes to all employment opportunities even outside the state. The language on the word of clause 2 is, no citizen shall, on ground only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible or discriminated against in respect of any employment or office under the state. So I'm again putting it, the word any employment here is of very wider significance and of wider amplitude. The word only put before the ground of discrimination is of also very significance, as it permits the discrimination on any other ground which are specified here. But that has to, of course, that has to meet the test of reasonable classification, as we had discussed in Article 14. The import of any employment, I have said you. So this clause is very important for that purpose, as it travels beyond the area of office under state. We will discuss the various judgments related to these two articles in my later videos, and we will finish the basic. First, we will finish the basic description and discussions and on the remaining two clauses first. We are giving halt to a journey today. We will resume our journey from clause 3 of the article 16 in the next video. Let me add here, the journey of article 16 is a journey of endeavor of creating a new social order of new India. It may be that it did not travel to the extent our founding father would have imagined or would have envisaged, but substantially the situation has improved, and so this journey is going on. Thank you very much for being with me in this video, and please visit the description of this video for further reference, and please subscribe my channel and communicate me of any idea which you feel after watching it, so that I can improve the quality of the video. Thank you very much. Namaste.